Hello everyone, this is Dietmar from Valideus. Just to let you know, we are going to wait another couple of minutes just to allow some people to come on. And as soon as everyone's on, we will then kick off with the presentation. So we'll start around about 1 minute past, 2 minutes past 4. So just bear with me. Thank you. Okay, everyone. I'm going to start the presentation. So good morning and good afternoon, and welcome to the Valideus webinar. As you can see in the title, Shaping the Policy for Future New gTLDs, 15th of August 2018. On the call with me today, we have... Oh, bear with me 1 second. We seem to have hit a little bit of a glitch immediately. Oops, there we go. Sorry about that, everyone. We had a little bit of a sticking there. On the call today, we have Jeff Newman, who's the SVP for North America for Valideus. We also have a special guest, which is Nick Wenban-Smith, who's the General Counsel at Nominet. In the room with me, we have Susan Payne, who is Head of Legal Policy for Valideus. Myself, I'm Dietmar Lenden, and we also have Ashley Roberts, who's a Senior Manager at Valideus. Before I pass the baton on to Jeff to start the actual webinar with his introduction, as you can see by the agenda, I have a couple of housekeeping pieces to bring to everyone's attention. If you have any questions or comments that you'd like to bring to our attention, you can either email info@valideus.com, that's info@valideus.com, or alternatively, you can use the chat box, which is on your screen on the right-hand side. We will attempt to answer all of the questions and or comments during the Q&A session at the end of the webinar, or if any other questions come up during the actual conversation as we're going through. But if we're not able to respond to all of the questions, we will email back with responses. And just to let you know, the webinar is set to go for 1 hour. So without further delay, I'd like to pass on to Jeff Newman. Jeff, you're it.
Thank you, Dietmar, and welcome everyone. So as the next slide is coming up, what we're really talking about on this webinar is about a paper that came out last month. It's a report from a group called the Working Group on Subsequent Procedures for the Introduction of New Generic Top-Level Domains. It is quite a mouthful to say the name of the working group, and we generally refer to the working group as SubPro for short. So this working group was established about or a little over 2 years ago to really look at the last round of new gTLDs, which was in 2012, so now over 6 years ago, and to look at how that process went and whether any modifications were needed to the original policy that gave rise to the 2012 round, which actually was over a decade ago in 2008. Whether any changes were needed to that policy or any changes needed to the implementation of that policy such that future subsequent, I'll call them for now application windows, could occur. And you'll see why I call them application windows a little bit later in this presentation. So just a brief timeline about where we are in this process and a best guess or estimate as to what the future timeline will be and when we are likely to see additional or the next application window for new gTLDs. So as you can see from this timeline, in early July 2018, the initial report from this sub-pro working group came out. And although I am one of the co-chairs of this working group, all of the discussions on this call are strictly on behalf of Valideus and not on behalf of the working group itself. So any projections I have in here are pretty much our own and not official timelines or projections, or any positions that we state are not official positions of the working group, but are more of Valideus and cum laude. In early September so in early July, this working group report came out, and there's a 2-month public comment window. The report is I think it's over 300 pages long, so it's quite a lengthy report with a lot of different recommendations. There are dozens of topics that were addressed in this report, and because of the length of the document, because of the number of subjects covered, the working group, instead of doing the normal 30 to 40-day public comment period, established a 60-day public comment period, and that public comment period is set to end in early September 5th. If you are interested in filing some comments or interested after this call and talking to us more about the comments that we, Valideus, intends to file, or are interested in help in crafting your own comments, please let us know, and we can work with you on that. The deadline, as I said, for comments on this initial report is September 5th, 2018. Just for the record, there's been one request so far to extend that deadline that was received by the group earlier this week, by the working group. So I'm not able to officially state that there will be an extension to this time period, but just pay close attention over the next week or so. There may be some additional time that's afforded to get public comments in. In September, so after the comments are received, the working group will begin assembling or analyzing those comments and working towards a final report, which is estimated to be completed in or towards the end of Q1 2019. That's a calendar quarter. If we can move on to the next slide. As the next slide's coming up, the work that's been done, or the work that was done with subsequent procedures, was divided into work tracks. The 4 work tracks that were referred to on the last slide pretty much cover every policy and every implementation issue, with the exception of the use of geographic names at the top level. Because of the high interest in geographic names at the top level, not only from the internet community, but also from governments, it was decided in 2017 to put that specific work into a new work track called Work Track 5. They are on a slightly different timeline for the time being. They will have their own initial report coming out hopefully in September of this year, with a final report from that group by the second quarter of 2019. If we can go on to the next slide. Looking ahead to the future, so what happens after these reports are done? Again, this is just kind of a best guess of what could happen, but ultimately this report, the final report, would need to be approved by what's called the Generic Name Supporting Organization Council, which needs to adopt those recommendations, and assuming that they are adopted, would then be passed on to the ICANN Board of Directors, who are required to have their own public comment period. But once that is done and the board does approve those, then it would go on to develop what has been called in the last round an applicant guidebook. Other people call it a request for proposals, but essentially we expect a guidebook to be published for public comment within about a year after the board approves moving forward with the program. And if all that came to fruition, we could see applications being accepted in somewhere in 2021, which, although that sounds far away, there is a lot that needs to happen, and so these next deadlines will move fairly quickly. If we want to go on to the next slide. So as I said, the subsequent procedures or subpro initial report has got dozens of topics. During this call, we picked out 6 topics that we thought would be of interest to the community to comment on. Obviously, there are dozens more topics, and as I said, if you wanted to reach out to us after this webinar to discuss any of those topics, we'd be happy to talk about those as well. The first one we thought would be interesting is, what will this mechanism for subsequent application windows be? And note that we're using the term application window because a distinction was made as to whether the next introduction of new gTLD should be in the form of a round, which was the way it was done last time. In other words, we collect a bunch of applications and then close the round, and then the evaluations take place, and we don't accept a new applications until the next round opens. Or do we do something called first come, first serve, which means we just open this up and whoever gets their application in first gets and it qualifies or passes all the evaluations, they would get the string? Or do we do some sort of hybrid model where we do 1 or 2 or 3 rounds followed by at that point in time we might be comfortable doing a first come, first serve application window? So what the working group had a lot of discussions on this topic, and although they have not made a very specific recommendation as to how all subsequent windows should be handled, the working group was pretty clear that the next application window should be a round, due to the fact that there has been at least 6 years so far between the 2012 round and today, and likely to be nearly 10 years between the last round and the opening up of this window. To do something on a first come, first serve basis didn't seem logical to the working group, and so the working group is recommending that the next application window be in the form of a round. But after that, the working group said, look, we're not making a specific recommendation on whether we do first come, first serve or rounds, but that ICANN should make it known that prior to the launch of this next round, that they should announce either a date as to when the next application window will open up, or a specific set of criteria that would need to happen before the opening up of the next application window. So an example is provided on the slide. It could say that the next introduction of new gTLDs after this next round will occur on a date certain, like January 1st, 2023, or something like 9 months following the date in which 50% of the applications from the last round have completed its initial evaluation. Again, that's just thrown out there as an example of a defined criteria. It's not one that has been agreed upon in any fashion, but really it's just an example of a date defined criteria. So go on to the next slide. Again, as the group didn't make a concrete recommendation as to whether it should be rounds or first come, first serve after the next after the next round, what some things did come out in the discussions that we think is sort of guiding the group. One is that a first come, first serve process would be very difficult to monitor for purposes of filing comments or objections. And so the governments made it pretty clear that, look, if an application could come in at any time and then be granted, and we know we only have, let's say, 30 days to file an objection, we're going to have to be monitoring the ICANN site every single day in order to detect when a new application is filed. And that's just too difficult. We think whenever the next application window does open, there should be some predictability as to when those applications are going to be accepted. And first come, first serve doesn't lead to that form of predictability. But on the other hand, others have argued in the group that, look, if you have first come, first serve, then we don't run into the difficulties of having things like contention resolution. So in other words, if multiple people apply for a single string in a round format, like happened in the 2012 round, we had to either do a community evaluation if they applied as a community, or ultimately do an auction, which led to a number of difficulties and issues, which we're not really going into on this call. But if we did a first come, first serve process, that would avoid all of those contention resolution issues that we had. I want to go on to the next slide. And this will actually bring up Nick Wenban-Smith, who's going to talk about the next issue, which is Registry Services Provider pre-approval. Thanks.
Thank you, Jeff. That's a very helpful introduction and overview. As Jeff alluded, the last round started in 2012, and there are still a number of applications outstanding some 6 years later, and really, even at the most optimistic forecast, it's going to be 10 years until the next round of applications. So what you can say, I think no one disagrees with the basic statement that the new gTLD program has not really been a byword for efficient and agile processing and working. There's a number of bottlenecks and excessive manual reviewing in a lot of the steps here. So yeah, it came initially, I think, from the registry's stakeholder group within ICANN's generic name supporting organization, and they made a fairly sort of obvious observation that there were a lot of inefficiencies that perhaps could be a quick win in terms of the next round to remove or reduce them in some way. And don't forget, the registries are the people who actually were making the application fees and applying for new gTLDs. So they had quite a sort of direct interest to make the process better and cheaper for everybody going forwards. So it was a sort of a fairly quick observation that the application process, as designed for 2012, involved a sort of a case-by-case assessment of each and every application for a new gTLD on a standalone basis. So they were all looked at each other in isolation without reference to other similar applications. And when you consider that, say for example, Donuts applied for 307, Google applied for 101. In terms of the registry services providers, the back-end operators providing the technical solutions, 70% of the applications came from the same 5 providers. Newstar on its own supported 350, and yet for each of those multiple applications using identical information, first of all, each applicant needed to complete a very long and complicated technical specification as part of their application process. And secondly, prior to any of these new TLDs being allowed to go live, there was then a further stage of quite extensive, what they called pre-delegation testing. So each and every one needed to be tested. And it led to a number of sort of perverse outcomes. Since applications were assessed not necessarily by the same people, you had different applications with identical information actually being given different scores, which was kind of very strange. And secondly, the pre-delegation led to a bottleneck in the rate that the really uncontentious and uncontroversial TLDs could actually be delegated. So it introduced a lot of inefficiency and a bottleneck, which a lot of people said didn't needed to be in place at all. So the observation was made pretty much that these are unnecessarily, costly and duplicative processes, and there must be a way which that could be made better for the next round if and when it happens. So if I could move on to the next slide, please. So the PDP working group, and this is work track 1 within the PDP working group. So just one of the groups was looking at this specific question. It was under the topic at the time called accreditation, i.e. you would have potentially accredited providers of DNS services. And then, quite symptomatic of it, a lot of time was actually spent discussing the word accreditation and what it meant and whether that was the right word. And they came up instead with what's in the initial report, essentially pre-approval. So your registry services providers could be pre-approved. And for the reasons I explained on the previous slide, there's sort of multiple processes all going through repeat testing and retesting. They have come to an initial recommendation that there should be some sort of pre-approval process for the registry services providers, so that when you were making your application, some bits of it were already essentially sort of pre-checked. You knew you were using somebody who was already up to a level of competence, and that meant that those things would not have to be sort of rechecked. Because if you think about it, there are now, coming up for 1,000 new gTLDs, a lot of track record and experience in running it. There have been very few issues technically with the new gTLDs, and actually perhaps this is something that a sort of a lighter touch process could be used, saving everybody time and money going forwards. So that seems good. But then there was a sort of a timing question, which is that, well, at what point does the pre-approval process need to be in place when you look at the timing of the next round? So, okay, is this another thing that needs to happen before the next round can happen? So they said, well, it should be in place at least 3 months ahead of the new round to now allow people to submit an application to be pre-approved ahead of the new round going live, so that then people who are interested in making applications would be able to see a list of pre-approved providers from whom you could logically make a selection. And then, again, sort of getting into the weeds of the various discussions now, it's like, well, can you only choose a pre-approved provider, or could you choose somebody who wasn't pre-approved and go through the same sort of extensive testing that was required for the first round? And the working group clearly felt that, and you need to consider this in the light that the whole purpose of the new gTLD program is to introduce choice and competition and to provide an open platform, is that you wouldn't limit people's ability to choose providers who weren't actually pre-approved and to go through some sort of other testing. So you can already see that, yes, in theory, there are some really good quick wins here, but when it comes to the detail of implementation of it, then, as I've put here, hopefully you can avoid a lot of the inefficiency and additional repetition, but it does depend a bit on, well, how exactly is this going to be implemented, and is the implementation itself going to reduce the overall burden on everybody, or is it just introduce something new and then a new and separate compliance regime which goes to everybody to actually add an additional step in addition to the things that are already there? And it sounds a bit sort of, I don't want to quote sort of Franz Kafka, but I can have a bit of a track record in doing things in the most complicated and over-engineered way possible. So this is quite a sort of legitimate concern. If I can move to the next slide. Thank you. So in addition to the report, it's quite a short section of the report and actually fairly readable. So if you're interested, you should have a look at it. But the working group have actually asked a series of questions where they were seeking input on the recommendation that there should be some sort of pre-approval process. So the specific questions, I've sort of summarized some of them here. But the initial question was, well, pre-approval, should the pre-approval process look at the types of applications that a provider is going to be supporting? So, for example, and this is where it gets a little bit complicated, it's not necessarily the number of TLDs that a provider would be supporting, but the size perhaps of the TLD. So it's a totally different proposition to support 10 TLDs with a few dozens of registrations in each of them than, say, to support one TLD with 3 or 4 million registrations, because it's the number of actual registrations which is perhaps more relevant to the capacity and capabilities of the provider. So how would you take that into consideration when you're looking at your pre-approval process? And actually it's more complicated even than that, because it's actually the DNS traffic. I mean, you'd think that would be related to the number of registrations, but actually you only need sort of one very important domain registration, say the BBC, which is the top UK domain. The bbc.co.uk domain has a huge amount of traffic in comparison to some other domains, and actually supporting that traffic is a huge responsibility commitment, requiring a lot more resilience and resource than, say, a niche .brand, which would have a fraction of that sort of traffic. So how would you design that within a pre-approval process? And these introduce some sort of quite sort of complicated, detailed technical assessment, particularly when, and this comes into the second question: how could you do this? You don't know ahead of the round who's going to apply, and you don't know until a TLD's gone live how many domain registrations it's going to attract, and you don't know really until the domain registrations are live how much traffic bandwidth they need within the DNS infrastructure. So how on earth would all that work? It seems quite complicated. So they're asking these sort of fairly open questions, and as you can tell from my explanation, it's not, you can see why they're asking the questions, because the answers are not that straightforward. The third question here is around reassessment. Essentially, you go through an approval process just ahead of the next round, but as you see, this round has already been 10 years. So does that pre-approval last you for the whole of the 10 years, or would you need to be kind of re-audited or rechecked at periodic intervals? And if so, how often, and what would that process look like? So, good questions, and it's very hard to make sort of informed comment really when you're considering windows of application in the region of 10 years. And the fourth question here around, if you're already an existing provider of registry services provisions to a large number of TLDs and have a good track record and no compliance issues, then can you just sail through to be automatically pre-approved without any sort of further work? I mean, as one of those existing RSPs, I would say yes, please. But then that leads on to sort of the comparison with non-approved providers going forwards, and would you need to do something to put them on an equal footing, and how does that all work in terms of a level playing field for to encourage, as ICANN's mission is, more competition and choice? How would you do that? So some interesting questions there. And then sort of a technical one around if you're going to apply for pre-approval, then what's the sort of the service level agreement on ICANN to turn that round to allow an application for pre-approval to be done and to be reviewed and checked, and what what's to stop ICANN sort of sitting on their hands, as it were, with a bunch of applications, and yet the application window is looming, and no one knows whether they've been pre-approved yet, and does that need to be built into the whole program? So, I mean, my summary around where we are on this is that I mean, I totally agree with the recommendation that there must be a better way to do the technical testing, the pre-delegation testing, you know, to repeat the same thing hundreds of times for the same applicant on the identical same information and technical solution just seems crazy. However, the way that the group is looking at it, and I do have some sort of concerns around the fact that this could introduce quite a lot of new work in a way which would eat into a lot of the time and cost savings that would be intended. But then my final thought is really, if we're looking at, say, sort of niche .brand applicants, you know, they really don't need all the consumer protections around security and resilience. These are sort of quite often sophisticated businesses on a B2B basis, contracting for all sorts of services, you know, network connectivity, hosting, all these other sorts of things, and there aren't any of the sort of the checks and safeguards put in place that ICANN is considering here, and you know, whether there still might be a very light touch route to allow those sorts of applicants to go through with the least fuss and inconvenience and cost ultimately. So that's for me on registry services pre-approval. I'll hand over now to Susan, please.
Thanks very much, Nick. Yes, I'm going to cover the topic of legal rights objections. So this is one of the ones that's likely to be of particular interest to brand owners. And it's essentially, what are the protections for your brand in place, or indeed what should be in place to protect you at the top level. So that's to the right of the dot. And just to be clear, the rights protections at the second level are not being dealt with by the subsequent procedures PDP. There's a separate working group that's looking at reviewing those, and it's running on a slightly different timeline, although the hope is that the recommendations coming out of that RPM's work will come in at a point where they can kind of dovetail with the work on next round. So I thought, first of all, I just on the slide included the two main recommendations from the 2007 policy, which related to this topic because it was considered in the previous round. And the first is that strings shouldn't infringe legal rights, and that expressly included a reference to trademark rights. And then the second was that there should be some kind of objection process in place in order to deal with this, so that those who were concerned that their rights were being or would be infringed by a TLD application would have some kind of avenue to pursue. Next slide. And within this subsequent procedures interim report, there aren't any specific recommendations being made about the legal rights objection by the working group, but there are two questions that have been asked of people. And the first is whether the standard that existed in the 2012 round should stay the same or not, and why. And then the second one refers to some specific revisions that were proposed by one working group member who wanted to try to address some of the disadvantages that they perceived in the current standard. And so they submitted a straw person red line, which did have some discussion during working group calls, but I think it's fair to say it didn't gain a huge amount of traction. And so the working group felt that it probably hadn't been aired sufficiently, and therefore specifically people are being asked to review those red lines and express views. So the first thing we need to consider then is if we're being asked whether the standard should stay the same, we obviously need to know what the existing standard was. And I've paraphrased it on the slide. And it essentially addresses just the trademark rights issue, registered and unregistered. And there's a standard based around a sort of infringement type standard that's probably quite familiar to a lot of people. It's that of taking unfair advantage of, or impairing the distinctive character or repute of the mark, or of creating an impermissible, that's hard to say, likelihood of confusion. Next slide. And then in the applicant guidebook, there were also a number of factors that were specifically set out that the legal rights objection panel should take into consideration. They were non-exhaustive, so they would be able to take other factors into consideration as well, but these ones were set out. And again, a number of these are sort of quite familiar types of factors that you might expect to see from an infringement context. And there's also some similarity that you would see in some of the factors that get taken into consideration in the UDRP and URS procedures, which deal with names at the second level. So there's a lot in there that's kind of familiar, and it deals, the factors deal with considerations that cover things like the degree of identity or similarity between the TLD string and the trademark, the nature and bona fides of the rights that the objecting brand owner has, the degree of recognition that the mark has in a particular sector as being that of the trademark owner, whether the applicant for the TLD string has any rights, whether they've got any legitimate reason to use the TLD, and whether the intended use as they propose to use it would create some likelihood of confusion. That's to paraphrase, they all look quite quite sensible, all look quite familiar. Next slide. So what were the actual experiences in the 2012 round of the legal rights objection? How did this play out in practice? And really that explains why some people are arguing that the standard needs to be changed. So in total, there were 71 of these objections brought, of which 2 were thrown out as being non-compliant. So there were 69 compliant complaints. That's another thing that's quite hard to say. And the vast majority of these, the applicant for the TLD string prevailed. In other words, the objection was not successful. There were only 4 cases where the objector was successful. And these have been categorized as 1 that was relating to a dictionary term, direct, and 3 that were categorized by WIPO, the panel provider, as having been non-dictionary terms, Del Monte and then WIPO in Pinyin and Chinese. And actually, incidentally, I'm not sure that the WIPO classification on WIPO is correct, because in translation that means microblogging, which is what they do. So their classification is a bit debatable, but suffice it to say, only 4 cases where the objector was actually successful. There are a small number of cases of that number of 69 where there were sort of 2 genuine brands going head to head. A couple of examples would be Del Monte and Merck, and actually both of those were cases where they were rights that have been split in the past due to sort of historic circumstances, and so the world has effectively been divided up, and so those are ones where the companies sort of coexist in the offline world, but in the case certainly of Merck, they regularly go head to head. The vast majority of the cases involve terms which had a dictionary meaning in addition to any brand meaning that they might have. So examples would be Coach for handbags, Academy, which is apparently a sports brand, or Moto, which is Motorola brand, relating to mobile devices and the like. And then within that category of the terms where there's a sort of dictionary meaning as well, there were a small number of terms, although actually quite a large number of cases, that involved someone who was a TLD applicant bringing the objection, and that TLD applicant had filed a trademark application to support their own support their own gTLD, and then were attempting to use that to give themselves precedence over sometimes quite a number of other applicants who'd applied for the same string. And so I think most people would feel that in those particular cases, neither of those applicants had sort of, if you like, genuine trademark rights. And I think people generally would feel that the legal rights objection process wasn't meant to be addressing those kind of cases. Not a particular surprise that in those cases the objector didn't succeed, but of course, as I said at the beginning, the objector generally didn't succeed anyway. And so, bearing all this in mind, and the fact that most of these cases did involve terms which did have another genuine dictionary non-brand meaning, not everyone in the working group necessarily considers that the legal rights objection process was unsuccessful or was a problem. But from the brand owner side, there certainly have been some concerns expressed during the course of the working group, and these are the sort of concerns that people who are thinking of putting public comments in might want to reflect on, and if they have any suggestions for how they might be addressed, that's certainly an area where the working group, I think, is looking for input. I think one of the big problems was that obviously if your brand is a non-fanciful term, your chances of bringing a successful LRO under the current standard, clearly are extremely slim indeed. One of the main difficulties that people have highlighted is that this kind of infringement standard is really quite difficult to assess at a time when the applicant doesn't even have the TLD yet. And so brand owners have argued, some brand owners have argued that it's very difficult to make out your case in the way that it's framed at the time you're having to make it, because you're reliant on any use that the applicant's already made, which in many cases they haven't made any. And you're reliant on what they say in their application. And so they may say all sorts of things about what they plan to do with their TLD, but you obviously don't know that that's actually how it's going to operate in practice. There have also been concerns about the pattern of behavior factor. One of the factors is how the applicant has behaved in relation to operating TLDs, but people have pointed out that, especially in this first round, people hadn't necessarily operated a TLD, but they may well have been something like they or the people behind the company may well have been someone who'd been involved in the domaining space and perhaps had lost a number of URSs and UDRPs. And so one of the proposals in the straw person is that should get taken into account as well. It also in the straw person, there was a suggestion that perhaps we should take into account the fact that if there are no proposals in place to safeguard the brand owner, then that's something that should be weighed in the balance. And finally, much of the concerns that have been expressed is really exacerbated by the fact that the panel decision is an all or nothing. So there wasn't really any opportunity. If the objector thought that the application was okay to go forward, they couldn't, for example, impose any conditions. They simply could either, refuse the application proceeding or allow it to go forward. Next slide, please. So in terms of things, what might be improvements, in addition to as I say, there is this proposal, a red line for some tweaks around the edges in terms of the standard, but there might be some other things that people may feel could be could potentially assist. One thing that's been floated is the idea of holding the applicant to their application. In the kind of hypothetical example, if someone applies for train and they say they're going to run it for train spotters and train manufacturers and rail companies, and there's a hypothetical again luggage brand that might be concerned about that, but obviously is in a different space, and we can see that they would almost certainly lose their LRO. Well, then shouldn't the contract that gets awarded to that applicant for train do something to ensure that they do operate it in the manner that they said they would? Now, one way that might happen might be for what's been called public interest commitments to be added into the contract, where they make some assurances about how they'll operate. That might be something that obviously an applicant could voluntarily do, but is there an opportunity for a panel to impose that? Similarly, is there a way to ring fence some terms that are in the field of the applicant? So in my hypothetical train example, terms at the second level that relate to luggage, well, maybe that TLD shouldn't be selling names that relate to luggage to third parties, because that's where the infringement risk would sit. Other things, parties obviously could, during the first round, could negotiate certain agreements themselves confidentially, but there wasn't really anything that would allow two brands to share, for example. Or even, if two brands went head to head, for both of them maybe to agree that neither of them would have that string, but they both would add something onto their TLD string so that they could both coexist. So those are all some of the things that perhaps might, around the edges, might help to improve the matter if you're looking at this from the perspective of a brand owner based on the current standard. And that's all from me. I'm going to pass over to Dietmar.
Thank you very much, Susan. It's Dietmar, yeah. I'm looking at the topic of closed generics. One of the things, and this has been run by WorkTrack 2, and as mentioned before, there's 4 work tracks that are currently working on SubPro and a 5th one that's working on the side. One of the things that WorkTrack 2 acknowledged from the beginning is that there isn't really a uniform definition of a closed or exclusive generic term presented in the 2012 applicant guidebook. So people did apply for generic terms, but there wasn't any restrictions against that. Specification 11 of the registry agreement gives an indirect definition of what a TLD is, a generic TLD, which possibly imposes eligibility criteria for registering names in that TLD, which could correspond to a generic string that limits registrations exclusively to a single person and or entity or that person's affiliates. So the WorkTrack 2 looked at that definition or that acknowledgement and came up with a couple of conclusions, recommendations, and potential questions. And as I'm in control of the slides, I'm not going to say next slide. So some of the options being considered. So what are the options that were being put forward? The first one is closed generics, formalize the status quo. So this is quite an important one because there isn't really a definition of what a closed generic is. So we need to try and find a way of actually formalizing a status quo. Closed generics that have a demonstrable public interest application. What evaluation criteria could be used? So what that means is that if somebody was to apply for a closed generic, we'll use Susan's example, let's say train, and they were able to show that they had a public interest in applying for that particular term, i.e. they were, let's just say, the Rail Safety Authority, for example. So they would put that into the application. I guess then some of the issues that arise out of that is how do you actually evaluate that what that Rail Safety Authority has put forward as a public interest is actually a public interest. So that's another question that the work track is looking at. They also looked at potentially putting a, if you applied, so let's say closed generics were permitted and you did apply for it, that you would put something into your code of conduct. So this would be that obviously that would mean that the applicant would have to adhere to some form of code of conduct. Again, this is something that needs to be fleshed out and discussed, and that's what the comment period, the subsequent comment period is all about, is giving input into these particular areas. Should closed generics be allowed? So no conditions. So in other words, anybody can apply, but there's an objection process. That's one of the suggestions that have been put forward. We'll have to wait and see what the public comments are on that, as well as how the working group or work track goes further on that. I would point out that some applicants in the last round did apply for applied for generics that were closed at the time because they were permitted. They weren't not permitted to do so in the applicant guidebook. And some of the reasons that they would have applied would have been, they could have been a little concerned that somebody else in the industry, not necessarily within the industry, but just a random applicant could have applied for it and sold second level names that could result in a malicious registration of names, spam, etc., of a particular sector. There is one particular example that we could put forward, which is .makeup. .makeup is a closed, it's a generic term that has a policy which is has a heavy restriction. So only people that are from within the makeup community, as determined by the registrant, the registry, is permitted to apply for and register a second level name. So the registry is actually going through the process of identifying who the potential applicants are and whether those applicants actually fulfill the criteria that they have set before they're actually able to get a second level name. So that's one way that it's currently working in the current environment. There are some pros and cons to that, but the WorkTrack team has been looking at that as well. Okay, whoops. So what are the WorkTrack has actually got two questions that they would like to get feedback from the community. Obviously, the stuff I spoke about earlier, that they would love to have feedback on all of those. But some of the other two main questions is, how could you evaluate a closed generic application that does not serve a public interest? So clearly, we would need to identify what a public interest is and how do you actually evaluate that. But then, obviously, then do some kind of process of trying to figure out how you would evaluate that. The second question would be, how should a code of conduct for closed generics serving the public interest be implemented? So again, how would you implement the code of conduct? What kind of information would you require from the applicant? Would you expect the applicant to put in question 18, if we're looking at the previous round's application process, would you expect them to put in all of their perceived uses of the TLD that could be used in a code of conduct? And then would that be put into the registry agreement? I mean, that's one example of how you could potentially gather information on the code of conduct. And then, whoops, there we go. So there were, I provided a list of pros and cons for closed generics that has come out of the actual subsequent procedures working group. I would make it very clear that this is a non-exhaustive list. So the first four look at the pros of closed generics. So it's a new type of business model, which is what the new gTLD rounds are all about. You know, it's bringing innovation and bringing new models to the market. This innovation could lead to greater competition and new services. So somebody with a closed generic could come up with some great and spectacular way of doing business. One thing that's quite common and brought up quite regularly is ICANN is not a regulator and should not try to regulate on issues related to competition and business models. So that does make it a little bit more tricky. There's also no real objective criteria for determining what constitutes a generic term or generic word. So this is something that the group felt is a pro, but it also is a negative. So that's just some examples of some pros. And then if you look at some of the cons or the negatives, generic words can be seen as a form of a public space. So the argument is that if somebody was to register train, for example, trains or train are things that the public get to use and as terms that the public use on a daily basis. So, you know, that shouldn't be reserved for a single applicant or a single applicant and its affiliates. There's an argument that, and this is basically what I just said as well, that closed generics could harm competition. So if there's one market player, we'll use train as well. Sorry, Susan, but we're going to use the same one again. If we look at train, you could argue that one train service ticket provider could potentially grab the .train name and use it to promote its services only, which would then impact on competition. One of the arguments that have also been put forward is that closed generics could favor large industry players. So for example, if we look at the train situation again, you could say that a large train operator in America probably has a little bit more clout than a smaller train operator in India, for example. So that large player could get the term train and use it to their advantage and disadvantage those that are in areas where they don't have necessarily as much money or as much ability to take part in the new gTLD round. And also, closed generics could undermine the goals of the trademark system, and I'll read this just to make sure that I get it correct, which forbid individuals from gaining exclusive property rights in generic names of products and an unfair competitive advantage in the marketplace. So again, that could boil down to the same example I used with the train company in America taking over and I won't say, and then being stronger than the one that's in central India. Which is quite a difficult situation. I would recommend that everyone if you have an opportunity and you feel strongly on the closed generics, to have a look at the documentation. It is a topic that's quite close to a lot of brands' hearts and for those that aren't brands, to be honest. So there we go. I'm going to move on now, and it's going to be Ashley.
Right, thank you, Dietmar. So I'm going to talk about string similarity. I'm going to begin with a little bit of background about the concept of string similarity and what the rules were surrounding it in the previous round. And then I'm going to come on to some of the suggested changes that have been put forward by the working group. So what is string similarity? Well, it's concerned with the extent to which similar strings can coexist in the DNS. And the idea is that if there's a pair of strings or a group of strings that are so similar as to be deemed confusing to the public, then they shouldn't all be permitted to exist as TLDs. So on this slide, I've got a couple of examples of pairs of applications or strings that were applied for in the previous round that were deemed at one stage or another to be confusingly similar. Can I have the next slide, please? So there were two mechanisms that we used to determine string similarity in the previous round. The first of those was the string similarity evaluation panel. Now, this was one of a number of evaluation panels that looked at all of the applied for TLDs. And this particular panel reviewed every applied for string and made a determination about whether it was confusingly similar to either an existing TLD, either a gTLD or a ccTLD, to a reserved top level string, or to another applied for TLD. Now, in terms of the kind of outcomes of each of those determinations, if it was deemed that a particular string was confusingly similar to either an existing TLD or a reserved name, then that application would be blocked from proceeding any further. If it was felt that the application was confusingly similar to another applied for TLD, then both of those, or the group of strings that were deemed confusingly similar, would be put into what was called a contention set. That contention set would then have to be resolved to determine which unique string would prevail. In the first instance, the members of that contention set were invited to reach some kind of resolution between themselves, so kind of do a deal between them. If they couldn't reach a mutual agreement, then the applications within the contention set would go to auction, and that auction was effectively run by ICANN. One thing to note is that the standard that the evaluation panel used to determine similarity was only visual similarity. So they were only concerned with the extent to which the strings looked similar. Next slide, please. So the other mechanism that was used to determine string similarity was the string confusion objection. So an objection could be filed either by an existing registry or by a TLD applicant against another TLD applicant, where the objector felt that either their registry or their application was confusingly similar. Again, I've got a couple of examples here from the first round. So if we just look at that first example, .NET was obviously a long existing TLD. The operator of .NET, VeriSign, filed a string confusion objection against the applicant for the .network TLD. VeriSign lost that objection, so the panelists determined that those two strings were not confusingly similar, which meant that .network was allowed to continue through the process to become a top-level domain. The last example on that list, .game was a string applied for by Google. They filed a string confusion objection against the applicant for the .games string, and Google actually won that objection. So the panelists determined that .game and .games were confusingly similar. And it's important to note a key difference in terms of the standard used for the string confusion objection versus the standard used for the evaluation panel. So with the evaluation panel, as I mentioned, that they were only concerned with visual similarity. With the string confusion objection, both the objector and the panelists could consider a much broader range of factors, such as oral similarity of the words and similarity of meaning of the words. In terms of outcomes of those determinations, they were effectively the same as with the evaluation panel. So if it was determined that the applied for string was confusingly similar to an existing TLD, then that applied for string could not proceed any further. If it was confusingly similar to another applied for string, then those strings would be put into a contention set together. Next slide. Great. So turning now to what were the suggested changes to string similarity put forward in the initial report. Well, the main one which came out, which seems to have general agreement amongst the working group participants, was around the treatment of singular and plural variants of a particular term. So that the working group suggested that going forward, that those single and plural variants of a particular term should not be permitted to coexist. And the idea behind this thinking was that it would clear up some of the inconsistencies that we saw in the first round. So in the previous round, there was no rule that said singulars and plurals of the same term could not coexist. But what that led to was subjective determinations that gave different results. So what we saw was that in some cases, just to give you one example, the term .cruise and term .cruises were both allowed to proceed and become top-level domains, whereas .kid and .kids were deemed confusingly similar and were not, and the same with .web and .webs. So while that had, while the idea of not permitting singulars and plurals had general agreement, there was less agreement on a couple of other suggestions that are put forward in the initial report, and they've kind of been put out there to get wider views and opinions from the community. And those were the ideas that translations of a term in different languages and synonyms should be considered confusingly similar. The third item we've got on this list, which you can find in the initial report, is that any strings or applications which are still being processed from the previous round, it should not be permitted that those strings should be can be applied for in any future rounds. So there's a very small handful of round one applications which are still being dealt with. Some are going through objection processes, others are going through accountability mechanisms with ICANN. And if those processes are still going on when the subsequent procedures begin again, then it shouldn't be permitted that those strings be applied for, which seems to make sense. And then the final suggestion we've got on this list concerns the string confusion objection. And it's been put forward that going forward, a party that files a string confusion objection should be permitted to file against multiple applications in the one objection. In the first round, a string confusion objection could only be filed against one application. But again, what that led to in some cases was some inconsistencies in outcomes. So to give you one example, the operator of the .com TLD filed string confusion objections against the two applicants for .cam. Now, because those objections were filed separately, they each had a different panel make a determination. And what we actually found was that one of the panelists determined that CAM and COM were confusingly similar, and the other panelists determined that they weren't. So it led to unequal treatment of the applicants, because one of the .cam applicants was not allowed to proceed with their application, and the other one was, which just seems patently unfair. So the idea of being able to group these strings together in a string confusion objection is that you should eliminate these inconsistencies in results. And those are really the highlights in terms of what's been put forward in the initial report on the subject of string similarity. As with these and with any other suggestions put forward, you're welcome to put in your thoughts and comments on these particular items. And indeed, if you have any new ideas for how string similarity should be dealt with, you're welcome to offer that in your public comment as well. So with that, I'm going to hand back to Jeff, who's going to finish off by talking about application fees.
Thanks, Ashley. And I know that we've gone a little bit over, but probably the question I get asked the most is, okay, so if we do have this next round, how much is it going to cost? How much is it going to cost to apply for a string? In the 2012 round, it was $185,000 per application. It didn't matter if you filed one application or 100 applications. It didn't matter how alike those applications were, or whether it was for a brand or for a generic. It was $185,000. That was it. That was based on a speculation, pretty much, of what it would cost to recover all of ICANN's previous historical costs on the new gTLD program. What it would be, it was projected to cost for evaluation, and a large contingency fund in case there were lawsuits or other problems with the round where they needed additional funding. There was applicant support available during the last round, but only one qualified for applicant support, and that one is pending auction, where there's no applicant support available during an auction process. So we're likely to have the entire round where not one application that went through got applicant support. In 2008, it was a philosophy of the group that the program should be self-funding, that it should be revenue neutral, and that the fees that were received from the new gTLD program wasn't to be used to fund other ICANN activities. We do have a surplus from the 2012 round. The exact amount of the surplus is up for a little bit of a debate, but it's somewhere around the $80 million mark at this point. So if you go to the next slide, just also to cover, to make sure, the group didn't discuss actual fees. In other words, it didn't say that, we agreed early on that we wouldn't determine what the fee would be, but more of an approach of how ICANN would determine what the fee for the next round would be. And the theme that kept coming up was, look, we still like the idea of the program being revenue neutral and that it be mostly on a cost recovery basis. But there were a number of the group that were worried about, but what if the cost recovery basis, what if there are thousands and thousands of applications? And it turns out that on a cost recovery basis, the fee would be so low to a point where it would encourage those that maybe didn't take applying for a TLD so seriously, or those that just wanted to warehouse top-level domains, or those that were speculating to apply. And so the concept of an application floor was discussed. This would be where if the cost recovery would be at such a low point as to where it would encourage speculation or warehousing, then a floor would be created, which would then determine what the application fee would be. So an example is that, let's say an application floor is set at $75,000, but ICANN believes that its cost would be recovered if you charge an application fee of $90,000. In this case, the application floor then the application fee would be set at $90,000 because it's above the floor. But if you look at example 2, what if ICANN said, you know what, we did a cost recovery analysis and it would only cost us $50,000 to recover our costs, but the group felt that a floor was needed of $75,000 because that was the point at which speculation would not likely occur. Then what would happen is the application fee would be set at the higher amount, which is in this case the floor of $75,000. If that were to happen, if there was an application floor and the cost turned out to be lower than the application floor, we would again have excess funds. And one of the things being talked about in the group and sought out for comment is if we do have excess fees in the next round, number one, we should set out what's going to happen with those excess funds, which was not done in 2012, but also seeks ideas as to what that excess money could be used for. So is it to be used for awareness of new generic top-level domains? Would it be used for universal acceptance projects to make sure that all applications can use new generic top-level domains? Or should it be refunded to the applicant? These are all things that are out for comment at this point, and are all things that we're interested, the working group's interested in hearing back from the community. If we go on to the next slide. So some of the questions that are out for comment, a couple of them we talked about already. One of the discussions in why the group recommended a floor approach is that without an application floor, as I said before, we may encourage speculation, warehousing, people to squat on their top-level domains. But if we do believe that that is true, then is there anything other than raising an application fee that could address that warehousing, speculation, or squatting? Because it was felt by some in the group that if the fee were too high or a floor were too high, then we're also punishing those from, let's say, third world or developing nations, or those from developing economies. We're basically setting up another barrier for them where they won't be able to, or may not be able to, apply for new generic top-level domains. So a solution, although having higher application fees would certainly discourage the speculation, warehousing, etc., it may also discourage those that we want to see apply for new gTLDs to actually apply. So are there other ways that we can get at making sure that there are no warehousing of top-level domains? And then, of course, is the magic issue of if we do have a application floor below which a fee should not drop, then how do we determine what that floor should be? The working group recommended that an economic study be done. Is that the right way to do it, or are there other factors, policy factors, or economic factors that should be considered when or if an economist does a kind of analysis as to what that floor should be? And then the final question is, should there be any exceptions to the rule that all applicants pay the same amount, no matter what? Should we have it depend on the type of application? For example, does a .brand application, should that cost less because it may not involve all of the same evaluations as a generic top-level domain? Or should there be different for geographic names? Or what if one party applies for 5 top-level domains and they're all the same application? Should there be any kind of, for lack of a better word, bulk discount in applying, or is each one the same fee no matter what? Those are the main questions on application fees. There's a lot more to cover, and we are already over. I think if we go to the next slide, it really intended to have a Q&A period, but given the time, we have collected questions during this webinar, and we'll certainly follow up all of them with an email. I'll turn it over to Dietmar to close out the webinar.
Thank you very much, Jeff. Hi, yes, thank you very much everyone for joining, and as Jeff said, we did run over slightly, but this is quite a meaty topic, so thank you everyone for listening in. There will be a video sent around, well, video of the slides and everything that everyone said that will be sent around. As the slide says as well, if you do have any questions or any comments or anything like that, please feel free to email info@valideus.com. Or Jeff directly if you have his details, etc., and Susan, etc. But yeah, I would like to thank everyone, all the speakers that came on today, and everyone for listening in as well. And I hope you all have a great day, and speak to you next time. Thank you, everyone. Bye-bye.